tend to speak loudly, so let me know if I'm blaring at you here. May it please the Court. I'm John Clendenin of Nyemaster Good here in Des Moines. I represent the Lindaman defendants in this action. I'm represented with my co-counsel, Kellen Bubach, at table of the Finley Alt firm representing defendant Mercy Medical Center, Des Moines. I'll be handling the arguments on behalf of all of the defendants this afternoon. Although I'm prepared to discuss all of the issues that are presented in the briefing, I'd really like to take the time today to address the statutory immunity issues that are presented in the briefing. If the Court has questions about any of the specific issues other than the statutory immunity, I'm happy to answer those questions, but I think the statutory immunity issue is the most important before the Court today. Ostensibly, Your Honors, this is a medical malpractice case, and I say ostensibly with emphasis on that word. It's brought by the adoptive parents of a little boy, Ethan, who was tragically abused by his biological father. Dr. Lindaman was one of Ethan's treating physicians, and the care was provided at Mercy Medical Center, Des Moines. I use the word ostensibly because Dr. Lindaman and Mercy are not being sued because of the care and treatment that they provided to Ethan. They're being sued, rather, solely based upon what Dr. Lindaman told the Department of Human Services and its investigators who handled the child abuse investigation and assessment in relation to Ethan. As such, this case, we believe, almost solely turns on the statutory immunity set forth in Iowa Code Section 232.73. Defendants believe that they are clearly entitled to that statutory immunity due to their aid and assistance to DHS in its investigation of the child abuse allegations and assessment of what is the best thing to do for Ethan at the time.
Does that statute encompass not only negligence claims, but also the claims in the petition that the conduct was reckless or willful?
Yes, it does. And the reason I say that, Your Honor, is the Siddiqui case of this court of several years ago focuses on where does the harm come from? What is the harm that is sought to be recovered through liability? And if the harm is what DHS either does or what DHS doesn't do based on the aid and assistance, meaning they either remove the child from the home or they leave the child in the home, then the Siddiqui case, Maples versus Siddiqui, finds that statutory immunity does apply. And anybody can allege anything, as the court is aware. Anybody can allege anything in the petition. But in this case, I think it's clear and beyond dispute that the harm that is sought here is the fact that Ethan was left in his parents' custody and control and allowed the ultimate abuse to occur. Under this circumstance, the Maples versus Siddiqui case would demonstrate that even if the conduct was negligent, or even if the advice and the aid and assistance was done negligently or could have been done better, the statutory immunity still applies.
To kind of boil down to, you have to make a statement that you believe is untrue. Is that if the doctor said something to DHS that he didn't believe was true, then that would be not in good faith, right?
Yes, I think that would be true. I think what you're saying is correct. I'll give you another example, Your Honor, that's even clearer to me. This case is easy in the sense that it's dealing with trained professionals, medical professionals, people who deal with this kind of thing, unfortunately, all the time. Let's change the facts just a little bit, and let's look at it as an intra-family dispute among folks who are not trained and who don't deal with this all the time, and frankly may not have the best motives involved. And let's say that I'm the father and I have an issue with my former spouse, and I'm going to use the child as a weapon in that relationship. If I go to DHS, or if I convince one of my relatives or friends to go to DHS and report child abuse on behalf of my child at the hands of his or her mother, and then I supposedly aid and assist in the DHS's investigation and assessment of whether or not that child abuse actually did or did not occur, I'm not acting in good faith. I can't be acting in good faith and acting to the aid and assistance of a child abuse assessment, because I know in my own heart and in my own mind that it didn't occur. And therefore, it's not so much whether or not, although it is true what you say, Your Honor, that if Dr. Lindaman had said something that he knows was not true, then we think that the statutory immunity would not apply. And that's really to the heart of what we're talking about here, is that the biggest beef, I believe, that the plaintiffs have with Dr. Lindaman is that he wouldn't answer the ultimate question. He wouldn't tell the DHS investigator, yes, this was child abuse, or yes, I don't believe the father. And ultimately, the statute doesn't require him to do that. In fact, when we're dealing with a subject matter as grievous as child abuse and as terrible both on the child but also all involved, don't we want the providers that are assisting to know their boundaries and not guess? That's essentially what Dr. Lindaman was doing here. I have treated Ethan. I have treated the left arm, the spiral fracture of the humerus, and in my opinion, if what the father says is true, then in my professional judgment, as a matter of biomechanics, the injury could have occurred in the way that he says that it occurred. I'm not willing and I'm not comfortable to go to you and say, I don't believe the father, or this was child abuse, because I haven't interviewed the father in that respect.
You have this affidavit, and this is what happens sometimes. I had this in practice when the lawyers draft the affidavit. Sometimes the word choice is less than ideal, which says that he refused to give an opinion, and you're saying that what he really means is he didn't have an opinion, or isn't that right?
I think that it's somewhere in between, Your Honor. I think what he's really saying is, and this is to the extent that you want to take a look at it, the whole text of the affidavit is found at page 21 of my brief. I think what he's saying is that I just don't feel comfortable answering the ultimate question. Here is what I know. Here is what I have done. Here is what I feel comfortable telling you that I honestly believe is true.
So you're saying refused doesn't mean refused in the sense that I had a definitive opinion, but I wouldn't give it to DHS.
Absolutely correct. The plaintiffs play these word games with the affidavit, and I agree with you. The affidavit maybe isn't as well worded as it should have been in retrospect. But they use this refuse language and this refuse argument throughout their brief and throughout the district court record. And it tends to cloud what really is going on here. And what is really going on is that Dr. Lindaman knew his limits. And Dr. Lindaman didn't feel comfortable speculating about things that he didn't know about, that he hadn't done the right kind of investigation to know about, that he knew was being done by other people who had a lot more experience and expertise dealing with than he did. So ultimately, if you look at the affidavit, which, by the way, the plaintiffs use one sentence out of the affidavit. If you read the affidavit in context, it says, I repeated the only opinion that I could help them with for their assessment, namely my opinion that, as a matter of biomechanics, the mechanism that the parents had described to me fit the fracture scene. So ultimately, we've got everybody in this case undisputedly agreeing that Dr. Lindaman provided an opinion. Dr. Lindaman knew that the DHS was conducting a child abuse assessment. He knew that the people he was speaking with, namely Darla Brown, the lead investigator for the case assigned to Ethan's case, he knew that she was in charge, and he knew what she was doing. He'd done this many times before. Anytime there's a non-accidental trauma, he testified, they, meaning DHS, comes and talks to me. Why do they come talk to you? Because they are trying to gather information from every source that they can gather it. And they may talk to one person about this part of the case. They may talk to another person about this part of the case. Very rarely are they going to talk to somebody who knows the entire spectrum of what happened. But DHS works a lot like a law enforcement organization in this respect. They take all of the information from all the varied sources, and they synthesize the information, and they apply their expertise, and they talk to professionals in the field that have a lot of experience with child abuse, and they synthesize the information and determine what they're going to do with it, how they're going to treat the child, and whether or not there is something to move forward with here, always thinking about the best interest of the child.
How was that process facilitated by providing immunity for those who assist in good faith?
Great question, Your Honor. I think that the answer is that these things happen, you don't know when they're going to happen. They can happen, as in this case, happen at 2 in the morning on an otherwise normal night. And the gravity of what's going on with the child and the parents requires that they move very, very swiftly. And that sometimes you really need the information right now, and I don't have time for you to think about it for a day. I don't have time for you to go interview more people. I really need to know what you think right now. And the immunity is part of the legislative history and part of the legislative intent of Section 232, is that we want you to feel comfortable talking to us at any time and give us everything you have, and don't worry about it, even if you get it wrong, so long as you believe what you're telling me, you're going to have immunity. And this case, while this case is about this case, it's very important for my clients, very important for Mercy. This case is about a whole lot bigger things than just this case. The way the plaintiffs have postured this case, they want to graft on to the statute a whole bunch of different requirements and a whole bunch of different steps that you're going to have to follow if you're going to prevail upon the immunity provided by the statute. And I would submit to the court that under the Maples case and under the Skolton case, the good faith standard solves all those problems. We don't have to ask all of those questions. And most importantly, the people we are relying upon to provide information to DHS to make the very best decisions they can as quickly as they possibly can, they don't have to litigate those cases. Because if I, as a provider, have the quote-unquote immunity, but I can only prevail through the immunity after a hearing or after a trial or after a summary judgment motion, it defeats the purpose of the immunity. The immunity is to avoid litigation. It's not a waiver, it's an immunity. It's a shelter. And the case here tends to, the plaintiff's view of this case tends to turn that upside down and will upset what is, in my view, a very well-run system. It's very interesting that this case, in researching this case and getting ready for the oral arguments and drafting the briefs in this case, there's only 4 or 5 cases of this court or the Court of Appeals that focus on this issue and focus on this statute. I would submit to the court that the reason for that is that the good faith standard, the subjective good faith standard, solves all of the issues that could come up before the court and allows the DHS to function timely, quickly, well, to provide information for the best interest of the
Why
case.
isn't the issue of whether the doctor acted in subjective good faith, why isn't that a fact question?
It can't be a fact question. And that's the point, is the subjective good faith standard is that, like the example that I gave earlier to Justice Mansfield, if I know, and if the evidence, everybody agrees that the evidence is that I honestly believed what I told you was the best information that I told you when I told it to you, and I honestly knew and honestly believed that I was being involved in an assessment or an investigation, that's all you really need. And if you have a fact question, like I said, it goes back and it defeats the immunity.
Is there any evidence in this record that the doctor was dishonest or that a fact finder could conclude this doctor was dishonest in what he told DHS?
None.
What would the practical effects be if we held on this record the immunity did not apply or was a fact question requiring a trial? Would that have a chilling effect on healthcare providers cooperating with DHS?
I think it would, and it'd be tragic. I think that the medical community is paying attention. But like I said earlier, I don't think we need to focus only on the medical community, because although that's the fact, those are the facts that we're dealing with here, this isn't about the medical community. It could be about me, it could be about you, Your Honor, it could be about your cousin, your neighbor, whoever. They need to be able to feel comfortable that by talking to DHS and doing the right thing for the child, whatever they subjectively believe is the right thing for the child, that they're not going to be hauled into court and they're not going to be run through the ringer for a year and a half and incur all kinds of attorney's fees and potentially jeopardy of a large judgment. Because when you start thinking like that, then you start thinking, well, you know, maybe I ought not get involved in this.
Well,
And that defeats the purpose.
My concern is this whole language about aiding and assisting in the assessment of this child abuse in this particular case, because you have a situation where literally then anybody that they talk to, and this kind of relates to more to the medical type of situation, anybody that you talk to is going to be subject to the immunity, whether you're really a willing participant or not. And I think the point of the plaintiff's case here is that he's not really a willing participant. He doesn't really want to offer an opinion. He really, because he doesn't know, or for whatever reason, he doesn't really want to get involved. Let's just put it that way. So on the one hand, he doesn't really want to get involved, but yet he wants the immunity from aiding and assisting DHS in their assessment. It just seems like there's a little bit of a divergence there.
I see my time's up. May I answer the question, Your Honor? All right. I think that I would respectfully disagree with the premise of your question, Your Honor. I think that you're inferring an intent into a hypothetical case that isn't supported by the record that we see here. I think that a different reading, and the reading that I would promote, is that Dr. Lindaman knew his limits, and he didn't want to get involved in speculating on things that he didn't know about, particularly when he knew that Dr. Sullivan was involved, that he knew that the DHS was involved, and all of the other parts of the case, all of the other moving parts of the case, were looking at the specific issues that he was being asked about. And he just didn't want to get out of his lane. And I think that, frankly, when you're talking about something as grievous as child abuse, that's really what we want people to be. It's not that he didn't want to be involved at all. It's that he didn't want to get out of his lane and speculate about things he didn't know about.
Thank you, Counsel.
Thank
You'll
you.
have an opportunity for rebuttal.
Thank you.
If you wish. Mr. Updegraff?
May it please the court, I apologize for my voice. I refrained from trying to be Christian Bale from Batman. I think your question, Your Honor, is the important question here in this case. What the plaintiff is complaining about is not the opinion that was provided. What the plaintiff is complaining about is the opinion that was refused to be provided to the Department of Human Services. Counsel accuses me of playing word games by saying that the word refused, that I'm misinterpreting it, that I'm engaging in semantics. All law is the interpretation of words. This particular affidavit, there's two sentences that I focus on. Number one, Dr. Lindaman says, because I knew that other people were evaluating child abuse, I made no effort to evaluate child abuse. Made no effort to do it.
And I understand that argument, which you've articulated very well in the brief. But here, here's the question. If Dr. Lindaman had simply said to DHS, I would prefer not to talk to you. I just don't want to talk to you. Would you have a cause of action then?
I don't believe that we would.
So
if he is,
how can you have a cause of action where he says something that he truly believes, and then your complaint is he should have gone on and said more?
well, my complaint is the manner that he goes about doing it. I mean, he makes a statement. If you look at the Department of Human Services records about what they say that Dr. Lindaman responded, they asked him questions about the veracity of the father's statements. They asked him questions about child abuse, and he characterizes his answer as a refusal to answer it. The Department of Human Services says that Dr. Lindaman just repeated himself. He said the injury fits the mechanism described. That's what Darla Brown has in her record. Now that answer seems to imply more than it gives. Mr. Clendenin gets up here and says, well, what Dr. Lindaman told Department of Human Services was this. Well, I'm only comfortable in giving you a limited opinion. And that opinion is limited to biomechanics, and that opinion is the injury fits the mechanism there. And I'm not willing to answer questions about child abuse, and I'm not willing to answer questions regarding the veracity of the father's story. That's not what the DHS record reflects.
All right, but you have two versions, but under either version, how do you get around the immunity? Under the DHS version, all he gave an opinion. He didn't refuse to give any opinions.
Thank you, and I understand your question. I apologize. The point of the matter is this, is that when the Department of Human Services asks you a question, they have a reasonable expectation that you will fully cooperate with them and give an opinion that you can give. And one of the genuine issues of material fact in this case is whether Dr. Lindaman could have formed that opinion. Dr. Lindaman says, you're asking, well, he honestly believes it's a biomechanical opinion, and maybe he does. But the question is whether or not he honestly believed that he couldn't reach the question of child abuse. where they couldn't reach the question of the veracity of the father's story. Because here's what happens in the record. Dr. Lindaman gives his limited opinion, which he doesn't tell the Department of Human Services is limited. And then the Department of Human Services convenes a multidisciplinary team and says, well, what are we going to do about this? Dr. Seelover reached the question of whether or not this was child abuse. Dr. Barron reached the question of whether or not this was child abuse. And then the Department of Human Services says, we took Dr. Lindaman's answer as, no, this is not child abuse. So we felt that we had to get a multidisciplinary team together, that we had to take that team and find an expert on the level of Dr. Lindaman. Dr. Lindaman being a pediatric orthopedic surgeon, Dr. Barron and Dr. Seelover both being pediatricians. They said, Trish Gowan said it specifically, Dr. Lindaman was the top of the line expert. And so we needed an expert on his level to say that this was child abuse. Because the Department of Human Services has this restriction. When there is a question as to whether or not it's child abuse, they have to take the least restrictive measure. They have to take the least restrictive question. And so when Dr. Lindaman doesn't answer questions that we contend he could have answered, when he refuses to get involved, when he decides I'm not going to evaluate because I'm going to sit this out, when he decides I'm not going to offer an opinion about the veracity of the father's story or or whether or not this is child abuse, he obstructs the Department of Human Services investigation.
Well, I mean, it still sounds to me like what you're doing is constructing a case over what he didn't say, and you acknowledge that if he had said nothing, there would be no case.
Well, it's certainly different, yes. I mean, if he'd answered simply, I can't tell you, and left the Department of Human Services with a yes, and I don't know, then I don't think the Department of when I say I don't think we have a case, I think the Department of Human Services gets a no contact order. What the Department of Human Services testified was that they believed that Dr. Lindaman gave them a no, that it was a yes, and a no. And then because it was a no, that they had to let that kid go home under the least restrictive concept. So when I say we wouldn't have a case, I don't think that Ethan Nelson would have been released to his parents, and I don't think he would have been abused if Dr. Lindaman had just said, I just don't know. But what seemed to happen here, and this is, you're saying I'm constructing a case and an argument, you have to do, because when you talk about intent, and that's what's really in question here, and this goes to Justice Waterman's question. When you're talking about intent, it's the most difficult thing for the law for any of us to see or understand. None of us are mind readers. If I could read Dr. Lindaman's mind and see what was in there and know what was going on, that'd be great. I also wouldn't be a lawyer, I'd be in Vegas playing poker, because I could read other people's minds. You know what I mean? You have to infer his intent from the questions, from what he said, and what he's done in this circumstance. You have to understand, Dr. Lindaman's testimony in this circumstance has changed over time. He went to the criminal trial, it's in my brief. He's asked whether or not he was asked an opinion about child abuse, and his response is, I don't recall that I gave an opinion about child abuse. He testified that I don't think I was even asked about child abuse. Then he sits down and writes an affidavit, picks some words that are intent words, that are absolute words. I made no effort to evaluate child abuse. I refused to answer questions about the veracity of the father's story. I refused to answer questions about whether or not this was child abuse. That's enough evidence to create a genuine issue of material fact as to whether or not he made a decision to sit out. And I understand your question of, I agree with you, if he said something that was dishonest, that would be a case. But that's not this circumstance. That's not what we're arguing about.
Can we focus for a second on the what he did say to DHS? In effect, said the father's version of what happened is plausible, or you know, the injury fits the mechanism described. And the father said I've got triplet baby. I've set a baby down hundreds and hundreds of times, and the father's version was the baby's arm was behind it, and that's how it was broken, just by setting the baby down. And didn't the doctor communicate that was plausible or fit, right?
That is what the doctor said. The question that was asked of the doctor was, would it be possible for a baby that weighs 8 pounds, 11 ounces to be set on the baby's arm and cause a spiral fracture of the humerus, which is, I mean, it's almost synonymous with abuse if you have that type of injury. And his answer was to repeat, the injury fits the mechanism described. Now the question, the difference there, and the question, the issue that I brought before the district court was, there's a difference between giving an opinion about plausibility and possibility. And with the Department of Human Services, probability. What the Department of Human Services is asking is, more probably than not, is this child abuse? That's what they're investigating. And saying something's possible, I think as we've all experienced in the law, is not exactly the most helpful answer to that question.
But is one of your claims in this lawsuit that he was negligent or even reckless or willful in blessing the father's version of events?
Well, and that's it's interesting, it goes right back to the intent question that you asked before about whether or not this is a genuine issue of material fact. Because I believe there's a completely plausible explanation for Dr. Lindaman's conduct that involves, he gave an opinion, he realized that that opinion was wrong, and so he's backed away from said opinion by saying the Department of Human Services shouldn't rely on me. It's not my fault. All those types of things, and that's what these affidavits really say. But at the same time, I can't say that definitively. I don't believe that Mr. Clendenin can say that definitively. It's just another one of the possibilities that a reasonable jury could conclude. And among those are my theory that he intentionally decided to sit this one out, which in my opinion means he's not acting in good faith, or that he's covering for a fact he gave a bad opinion, or his testimony that he refused to give an opinion, or Dr. Lindaman's testimony that he didn't give, wasn't even asked in the first place.
Well, counsel,
Go ahead.
Just quickly, what evidence in the record would permit a jury to conclude that he was dishonest when he said the father's version of events was plausible?
It's not really my claim that he was dishonest about that particular opinion. My opinion is that if you're looking for dishonesty, the thing that he was dishonest about is whether or not he could reach an opinion about child abuse and whether or not he could reach an opinion about the veracity of the father's story. Because as you've talked about, I've got 3 babies of my own. I mean, I can tell you that I don't cause spiral fractures by putting them down on their arms. And what Dr. Barron and Dr. Seelover talked about is that with flexor tone, a baby of Ethan Nelson's age, I think he was 3 weeks old, has flexor tone. He's got the weight room problem. He can't flex his arms and get them behind his back in the first place. I mean, the probabilities, certainly it's possible, but the probabilities here weigh so far in favor of giving an opinion that this was child abuse that it was virtually a no-brainer for Dr. Seelover and Dr. Barron. When Dr. Seelover heard that it was Dr. Lindaman's opinion that it was plausible or possible, his response is, "You got to be kidding me. You've got to be kidding me."
well, counsel, I'd like to just go back a little bit. And I heard your answer to Justice Mansfield's question. Sure. And as I recall your answer, when he asked you if Dr. Lindaman had just declined to answer any questions, I think I heard you say that wouldn't be actionable, or at least it wouldn't.
I understand.
Yeah. But then I, as you went along in your analysis, I thought I heard you say, by Dr. Lindaman's sitting out an aspect of the inquiry or investigation, that's evidence of the absence of good faith taking him outside the immunity, and that's the piece I still don't get. Well, and the reason, let me explain what I'm having trouble with. It seems to me possible that the doctor could say, all right, I'm asked about the mechanism of the injury, and in my opinion, it's plausible that the injury could have been sustained the way the doctor said it happened.
Right.
And then when other questions come, follow-up questions, well, but with this additional information that we're going to ask you to assume, is your opinion still that way, that it's plausible? And the doctor just simply says, look, I've weighed in as much as I'm comfortable weighing in on the limited information I have so far, and I'm just disinclined to go further. Why does that kind of response take him outside the immunity? That's the piece I don't understand.
Sure. It's a circumstance, and I'm sorry, I did give a confusing answer to that previously. Let's put it this way. I think that if a doctor answers, you can simplify this, and it's dangerous to do it, but you can simplify Dr. Lindaman's potential answers into 3 possibilities: yes, no, or I don't know. And your question is if he says I don't know, why doesn't he get immunity? I think that's what it breaks down.
I don't know, or I'm unwilling to speculate about that.
Fair enough.
Yeah.
I think at that point, you'd get to look at his subjective intent in terms of whether or not that he's being truthful and honest about saying, I don't know. Could a doctor in Dr. Lindaman's circumstances, and this is why it's captioned a medical malpractice case, could a doctor in Dr. Lindaman's circumstances have answered that question? And the fact that he refused to do so, what is his intent in doing so? The idea being is that we want to encourage full cooperation under the statute. But if a doctor, but in this case, I think there's a genuine issue of material fact as to whether or not I don't know is a truthful and honest answer. In a circumstance where it would be, where we didn't have Dr. Seelover and Dr. Barron saying this is a no-brainer, essentially, where we have 3 experts from the plaintiffs who say he should have evaluated child abuse in the first instance, even though he decided not to, and that he could have answered this question. And that
Is there evidence in the record that he said, I don't know?
it doesn't appear that he did. It appears that he
It
was.
sounds like he just declined, like you, I think you used the word sit it out. I mean, that seems to be a fair summary of what he says in his affidavit, right?
I would think so. I mean, I look more to the Department of Human Services record of what he said. They said we asked questions, and he repeatedly said the injury fits the mechanism described, which, I mean, anybody who's cross-examined somebody knows how that answer is evasive. It doesn't directly answer the question, but it appears to answer the question. And that's the problem is that I don't understand why if he had said outright, I don't know, I just don't know, and that was truthful and honest, I think he gets immunity. But if he says, I don't know, and he's doing it so he doesn't have to come testify at trial, because the big elephant in the room here is this. Dr. Lindaman doesn't get paid by the insurance company or by anybody to go testify at this criminal trial. He knows what he's saying, what his affidavit is susceptible to an interpretation is, 2 other people have already said this is abuse, so I don't have to. They can go bear the burden of doing this. And what we're submitting here is in the state of Iowa, he has more of an obligation to his patients than that. So thank you.
Rebuttal?
Seems like the question du jour is, did Dr. Lindaman sit this one out? And I would submit to the court that he did not. This isn't a case where we're dealing with a rural county hospital in the middle of the night where Dr. Lindaman is the only doctor on staff and he's the only person that could provide information and provide input to DHS. Dr. Lindaman is a smart guy. He knows that there are many other experts who are already involved with this and who are already talking to DHS and who are already providing information to DHS, and he hadn't had the opportunity to evaluate the questions that DHS was asking him. Is this child abuse?
I'm just troubled. I mean, we're dancing around the words of the affidavit, obviously.
Yes.
And I do understand your argument. But the words of the affidavit are somewhat ambiguous. I mean, what does the refusal mean? Did it mean, I got an opinion, but I'm not, that's one, I suppose, theory. The other is, well, I just haven't formed an opinion because I don't have enough information. They're all plausible, but there's some ambiguity in the affidavit. And obviously, the burden is on you to show, as you accept, I think, as a matter of law, that you're entitled to this immunity. I'm struggling a little bit with what I see as at least some error in the affidavit. I'll call it error, some leakage, that allows an inference to be made that, well, maybe he sat it out, but maybe he just didn't want to get involved. I mean, the pecuniary motivation is offered here. Close it up for me. I think you understand my question.
Yeah, definitely, Your Honor. Thank you. I think one way you can close it up is let's surgically remove the affidavit. Let's act as if the affidavit never existed. No, it couldn't be good, it couldn't be bad. Let's look at the totality of the circumstances of what's going on. Darla Brown, her assessment report, found in the joint appendix, has no less than 11 separate references to the input and assistance and aid that Dr. Lindaman provided. The assessment report contains the impact of those aid and assistance, or impact of those contacts with Dr. Lindaman. And essentially, if you boil down what the plaintiff is arguing today is that in order to avail himself of the immunity, if there are more than one doctor involved, anytime a doctor develops a very detailed opinion, then in order to get the immunity, I'm going to have to take another step further in order to make sure I've done everything that that doctor has done. And I think that that's an absurd result, and it's not one that is required by the statute.
I don't quite think he's saying that. I think what he's saying, in order to get the immunity in this kind of case, you have to say, you have to be more specific. And you have to say, I just don't have enough information to form a specific opinion, so I don't offer one. Now, if that had been said, I guess I rather assume we wouldn't be here today. 'Cause that does take the air out.
Yes.
But that's not quite what we have.
I think, going off of Justice Mansfield's question to plaintiff's counsel, is it, if he hadn't said anything, if he had just stayed silent, or if he had said, I just don't feel comfortable talking to you about that, would there be a cause of action? And I think Mr. Updegraff said no. The question I would posit to the court is that better? Is that better? Is that a better policy for the state of Iowa?
Let me ask it this way. I mean, I think, sort of the high water mark of the plaintiff's case is, it seems to be kind of, as we go through it at this oral argument, seems to be your client gave an opinion that the injury, it was plausible that the fracture happened the way the father described. And then he harbored other thoughts about the case, but he declined to give those other thoughts. He sat out the rest of the interview. That's sort of the high water mark. Is that enough to establish a lack of good faith under the immunity statute?
I think if you had...
And if not, why not? Go ahead.
I don't think so. And I would attack the premise even further, is that there's no evidence of that.
I know you disagree with the premise, but let's say that's the high water mark of the case.
If the doctor had other thoughts that he wouldn't relay to DHS, or didn't feel comfortable, or for whatever reason didn't relay, I think that then you are then looking at the statute and saying you have to participate fully in the aid and assistance, or you have to participate fully in the investigation and assessment. And that's not what the statute says. It says any aid and assistance. And those extra requirements are not in the statute, and it's a statute that's worked very well for a long time. Thank you very much. Appreciate it.
Thanks to counsel for the excellent arguments. The case is submitted. Bailiff, you can please adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.